Issue people, right? We don't have all the right answers, but we do respect and we do have a common goal. We are constitutionalists. We know what's right and we know what's wrong. We know that for men to be free, you need a moral people. We know the fundamentals. In the Virginia, well, it's dangerous for me to do this, so I guess that's historians in the room. In the Virginia constitutional battle, and it was a battle. You had two stalwarts. You had Patrick Henry and James Madison fighting it out. Well, it worked out okay, right?
Yeah.
Yeah. All right, so maybe we're going to do some fighting out on this whole topic tonight, too. And that's fine. What we're going to do is we're going to have two presenters. They're going to go 20 minutes each, okay? And then we're going to open it up, and we're going to have a Q&A period. No speeches. You're going to address the chair with your Q&A. We're going to allow both parties to address it, okay? That's the fairest, balanced way we can do this and try to get as many people involved as we can. Agreed?
Yep.
Good. Okay, go. Bob Menges is with us today. Thank you for being here.
Wait.
Yes.
Excuse me. David is our timer.
Oh, we do have time. Yes, we do.
Sit over here so they can see you. He's going to do like this when the time's up. You have 3 minutes to answer the questions, and he's going to let you know when the questions are up. That's for Bob.
Who's David?
I didn't see. I'm sorry.
David.
I got you.
David's the timer. And Jesse and you have 3 minutes to answer your question. For the people who are asking questions, David, you want to count them?
Whenever you ask a question, make sure you don't make a speech. Don't make any comments preceding the question. Ask the question, and then we'll have 3 minutes to answer.
Fair enough? Easy enough?
That is to give maximum time for them to answer the question instead of the time being eaten up.
Otherwise, guys like me would go on forever. When Bob walked in today, I said, well, we've met so many venues. This is a true patriotic constitutionalist. This is one of us, okay? He's representing one side of this whole state's convention issue. He can introduce himself, a little bit of background. I know he's been a constitutional scholar for over 15 years. I know that he and Ray Nash got involved way back when, talking Constitution while you guys were studying. And this relationships to our friends, our associates, ourselves goes back a long way through various relationships we have. So please welcome Bob. I know he's got a lot to say, and the floor is yours, my friend. Thank you for being here.
There's a card of mine in the back. Please pick one up because it has a website where you can get to a video that has an entire presentation on this. In 20 minutes, there's just no way that I will be able to go through and give you an explanation, a full explanation of Convention of States. I'm going to do some tonight, but I urge you to do that. It takes into consideration all of the arguments, but you really need the history behind it. If you're going to be a constitutionalist, you have to do that. So yes, I am Bob Menges. And just real quickly, because I don't want to eat up my 20 minutes with that, but I need you to know a little bit about my background. He talked about 15 years. About 15 years ago, 16 years ago, my wife and I started homeschooling our kids. Folks that are against Common Core today, it's a new name. We saw it a long time ago. So welcome to the war. But anyways, I began teaching a course on constitutional law to homeschooled high school kids about 15 years ago. I'm a government politico geek like you are. History freak, love the colonial era, the Revolutionary War era, and love the Constitution. Been teaching the Constitution to these young people. Some of them are here with us tonight to explain the separation of powers, particularly original intent. As constitutionalists, we have only one place to go, and that's original intent. The living Constitution is nonsense and garbage. I'm sure most of you here that are here tonight understand that. But it's crucial that we teach the next generation those principles so that they can articulate them. Not just walk around and wave a pocket constitution. Too many of us do that. Those kids can articulate it when they're done with that year-long course. That led into some speaking opportunities. I had some folks in my church ask me, because my other passion is to teach biblical worldview. So, I'm trying to keep watch my own time here. But anyways, teach biblical worldview. So some folks in my church asked me, Bob, would you put together a course to teach the biblical worldview of government and some of that Constitution stuff that you do? So I have a 12-session course that's on that website that's nothing about Convention of States. It's about the biblical worldview of government and then the United States Constitution and American government. So I urge you to take that no matter where you come down on this issue. Honest people can disagree. But those speaking opportunities and a providential meeting about 8 years ago with Tim Scott, who was a county councilman, led to a great friendship between me and Tim. Of course, now you know he's a United States Senator. But when he ran for Congress in 2010, Tim asked me to mentor him because he knew that that was my thing. So we met at a Barnes & Noble on Rivers Avenue every Saturday morning for about an hour and a half. And that's the kind of guy that he is. He wasn't afraid to ask for that kind of help. The guy's a real constitutionalist. We won't always agree. Him and I have even butted heads. But the man is an humble man and now a constitutionalist. Some of you may know I was with the Boston campaign last year. I considered running for Congress, and then my wife and I, after praying about it, decided that wasn't the right time. So I was the senior campaign advisor for Curtis Bostic. And 16-member field, we came in second place, which to us was a win. And now I'm actually helping out some of the candidates to get rid of Senator Graham. I've worked with probably 4 of them, but and I have selected the one that I'm going to support. But I will tell you this, and this isn't to boast, this is just to set context, so that I have a little bit, so I can set some credibility with you for those of you that don't know me. Senator Bright, incredible constitutionalist, called me 2 Saturday nights ago because he is the guy that sponsored the personhood bill. We had a long talk about Roe. He was looking for some counsel on where to go in his in the hearing that was held, and of course they weaseled out in that hearing too, just like they did yesterday. But anyways, with all that said, I'm going to talk to you a little bit about the Convention of States. Back in September of last year, probably I'd say about a year ago, maybe a year and a half ago, I came to the conclusion, one of my passions has been, and the kids will tell you this, and anybody that knows me will tell you, my passion is that we teach that us as conservatives need to understand the Constitution. I'm not talking about just, some of the basics, but I mean as citizens, we need to understand more than just the basics. Article 1, Article 2, Article 3. What are the enumerated powers? What are the checks and balances? Because we're electing people that have no idea what those things are. And we elect them because we don't know what they are. So it's crucial for us to make sure we elect people that have mastery of this document. It's one of my things last year in the race that we were running in the 16-member races. I was telling people that whoever you pick, make sure they have mastery of that document. You wouldn't ask someone to go build a bridge who didn't understand how to build bridges. But we do it all the time. So anyways, that's my passion. But I began to see that we need to open up a second front. I've taught Article 5 for years. And to be honest with you, years ago I just gave it cursory look, and I was in the same position as my opponent here tonight, Jesse Grafton, who's doing a fine job leading the effort that he's doing. But obviously we know that he's here opposed tonight. We know the John Birch Society is opposed to what we're doing. But what I want to say is that those things came to mind to me that we need to open up a second front. I had the same view that there was this deep fear of a runaway convention, a con-con. I started to look at that and began to even look at the term. Those of you in here that have heard the term con-con or use it, let me just encourage you, even if you totally disagree with me at the end of the night, quit using the term. Because it betrays a level of misunderstanding of what happened in Philadelphia in 1787. Nobody there called it a constitutional convention. Not until about 50 years later. That was the Philadelphia, if you were to transport back in time, that was the Philadelphia Convention, the Great Convention of 1787, or the Federal Convention of 1787. Not until years later did historians look back and tag it as such. Not wrong, there's nothing wrong with that, but today the word con-con is used pejoratively or negatively to shed what we're doing in a negative light. And just be honest with you, just make sure that if you're going to take a position against something that you've really looked at all the facts and have a solid argument behind it. But I began to see that this is something that really needs to take place. And in other words, the founders gave it to us. It's in the Constitution. Article 5 is not some fad. It's not some way out there idea. The founders gave it to us. This is part of the Constitution. It's crucial for us to understand that. It's not something that we're treading, be careful with. We're wringing our hands today about something that the founders gave to us for a time just like this. Glenn Beck puts it like this. He says, this is the break glass in case of emergency. How many of you in here tonight think that the federal government is out of control? I'm going to suspect every hand is up. The question is, what's the approach? I understand that. The founders gave us something for a time just like this. Can I get someone to turn one light down or so everybody can see the projection? But they gave us a solution, and it's called the Convention of States. One of the things that I saw in the flyer, the advertisement that went out tonight, and I'm not trying to disparage whoever put the advertisement together, but it goes to what I said a little while ago about the importance of understanding history accurately and facts. And on this advertisement, I understand the spin and the leaning towards one area. I get that, and I'm okay with that. The Constitution in flames, I'm going to assume that means that not I want to put it in flames, that it is in flames. It is. I like to say that it's being perverted, and I'm going to show you some of that, explain some of that. Hopefully, maybe some of your questions will do that. Mr. Grafton is here to enforce. I've been teaching enforcement for 15 years, so I'm not against enforcement. So lest any of you look at the flyer and come away with that conclusion, that's not my position. Above my head, you'll see the word revise. As constitutionalists, use the proper terminology. For those of you that hear and see that word here tonight, it's not revise, it's amend. The Constitution has a process for amending it. Matter of fact, I would hope that none of us in here are against amendments, because the founders gave us that process for a reason. The first 10 amendments, known as the Bill of Rights, were amendments. If they're revisions to you, that's okay, but they're good revisions. They were amendments that we need. I would submit to you all but 2 of our 27 amendments are pretty good. The 16th and the 17th were horrific. We were asleep at the wheel in our country when that happened. But the United States Constitution, Article 5, has 2 methods to propose amendments to the Constitution. So I do want to give you a quick briefing on that. The first process that's in here, the first process is the one that's been used for all 27 amendments. So if those of you here tonight and you already know this, forgive me and bear with me. But for those of you that are not, I want you to understand what Article 5 does. It has 2 provisions to amend the Constitution. The first one is known by most, if not all of us. When 2/3 of both houses of Congress propose amendments, keyword is propose. They can only propose amendments. They send them out to the states, and Congress tells the states whether to ratify them in the legislatures or to ratify them inside conventions, not to be confused with a convention of states. That's a convention that we've held in each state to ratify. Every amendment except one has been ratified via this mode. Only one has been ratified via that mode. That's a little fun fact of history. If you want to ask me later, I can tell you why, or what I think it was why they did it, and which one it was. So that's the first mode. We call them modes. The second mode, the history behind this is incredible. And one of the things that I didn't say at the beginning, you might have picked up on, I like to teach Christian worldview, and that is that it's crucial for, if you're a Christian here tonight, it's crucial for you to understand the biblical foundations of our doctrine. If you're not a Christian here tonight, then bear with me. I'm not trying to offend you, but I can only teach it from that avenue. And I would submit to you, and when you look at the history, the hair will stand up on the back of your neck. When you see how we got this mode right here, I believe it's a providential hand of God that we got this option for the states right here. That God gave those men, He put wisdom. Everything they did in the Constitution, they weren't perfect, man. They weren't flawless. But God put ideas into their minds. Ideas about the rule of law, about law being higher than men. Because the prevailing idea in that day was that kings were law. Rex lex versus lex rex, which means law is king. But this process right here, when 2/3 of the state legislatures propose or file what's called an Article 5 application, when they propose or when they call for a convention, they have to submit an application. We have a bill in the South Carolina House and the South Carolina Senate. Representative Taylor introduced the bill in the House. Senator Grooms, many of you know, introduced it in the Senate. And when those 2/3 of those states call for a convention, the Constitution says that Congress shall call the convention. There's no ifs, ands, buts about it. I know there's all kinds of other things said about Federalist 85. Alexander Hamilton says that they must, the words of Article 5 are peremptory. They must call the convention. And then it has to be ratified. You notice anything, just like the previous slide, they look identical. There is literally no difference between this mode of proposing amendments and the previous mode. The only difference is in modern language, I would say that George Mason is the guy that gave us this. He stood up at the convention and asked for this because he was opposed to too much power centralized in the federal government. And he stood up. I would submit to you that he created an end run around the federal government, around Congress. The only difference between this and the mode that's been used for all 27 amendments is that this originates in the states, and Congress has no role in the convention other than to call it and to specify the mode of ratification. It literally is an end run around Washington. Who in here would not like to go around Washington and get things done? I think all of us would want to do that. The process is that 34 states out of 50, the president says there's 57, but you and I know there's only 50. So 34 states, 2/3, 34 states have to call it. Congress is required to call the convention. Delegates are selected by the state. Bob, how do you know that? Well, ask me that question later on. I'll be glad to tell you. Proposed amendments are sent back to the states for ratification. If 38 states ratify, that's 3/4, then those amendments become part of the Constitution, just like the first mode. Exactly the same way. Nothing is different. People say, well, Congress will take it over. Let me explain something to you, those of you here tonight. Congress right now is in a perpetual con-con. If you want to call it a constitutional convention, our United States Congress is in a perpetual constitutional convention. They can propose amendments anytime they want. People always say, well, they're going to take over and propose rogue amendments. Why don't they do it now? Why don't they propose rogue amendments now? That's an interesting question some folks have to answer, and I'll be glad to answer for you later. The founders knew the federal government might one day become drunk. I call it drunk. I say our federal government is intoxicated on powers that they are not supposed to have. Their powers are few and defined in the Constitution. The most important check to this power, the most critical check, they gave it to us. They're screaming at us from 227 years ago, asking us, what are you waiting for? They specifically gave it to us for a time such as this. Article 5 gives the states the power to call a convention. Look at that. I want you to get this. If you don't get anything else tonight, get this little piece of history. The Philadelphia Convention ran from May to September of 1787. 5 months. On June 11th, the only process that was in there, in the amendments that were being made to the Articles of Confederation, and please ask me that question later on too, that one always comes up. The only provision for amending this document, what would become the new Constitution, was what George Mason called the national legislature. He says amendments are going to be necessary. He says, and it'll be better to provide for them an easy, regular constitution, a constitutional way, and that to trust to chance and violence. It would be improper to require the consent. Today we call it the Congress, he called it the national legislature. Remember, it hadn't stood up then. We've got to get our historical context down. But they didn't do anything. They tabled it. In other words, he was asking for a mode, a process whereby the people could get amendments if the federal government became oppressive and abusive. Are they oppressive and abusive today?
Yes.
No, and then on the September 15th, those of you that are constitutionalists, what's Constitution Day? Real quick. 17th of September, 2 days before the end of the convention. And I would say by the providential hand of Almighty God, George Mason stands to his feet again. He says, listen, no amendments of the proper kind are ever going to be obtained by the people if the government should become oppressive. The guy was prophetic. He's telling us into the future, and he was very leery of too much power in the central government. On that day, 2 days before they finished the draft and sent it back to the Continental Congress, 2 days before, they approved it and they slipped this mode in there. This provision was given to us in the Constitution. Look at what Madison says. Madison was one of the last living founders. People were asking him all kinds of questions. He died in 1836. In 1830, he was written. Many people would write him and ask him. He was a very sickly guy at the time. But the guy would get up and still write. He would write out those answers. And we know that because in the letters you hear about it. He talks about his ailments. They didn't know what we call them today. But here's what he said. He said, should the provisions of the Constitution as here reviewed be found to not secure the government and the rights of the states against usurpations, listen to this, and abuses on the part of the United States. Listen to what he's saying. Resort within the purview of the Constitution lies in an amendment of the Constitution according to a process applicable by the states. Madison, if you go pull that letter up. I think we have a copy of it. We can give it to you, or I can send it to you on the website. It's a fascinating read. The Constitution is legitimate. If you're a constitutionalist, Article 5 is legitimate. It's not some radical idea. I'm not trying to be melodramatic, but I'm standing on the shoulders of George Mason, James Madison, and all of those founders because they gave it to us for this time. We intend to use the Constitution to save our liberty. I would love to take the time to explain this to you, but the history behind this is fascinating. I can't go into it for lack of time. But this man, George Nicholas, nobody knows him today. Pick up one of my cards. The quote's on the back. It's a great quote for you to share with people that don't understand what has happened. He said, an enlightened people will never suffer what was established for their security. This was at the Virginia Ratification Convention in 1788. My students can have this memorized. If I ask them, why are they doing this today? If I'm standing up in class, every Thursday night, I stand up in class, and I explain to them, this is what's going on, we're dissecting the Constitution, and they'll say, well, Mr. Menges, if they're supposed to be doing that, why are they doing this? And you know what the answer is by mid-year? George Nicholas. Because they've come to understand, George Nicholas told us what would happen. If we didn't have it, they called it enlightened. They meant knowing or understanding people. If we didn't have people that understood the document, it would be perverted. Today it's perverted. The picture shows flames. I would submit to you it's being perverted. The Constitution as interpreted by the Supreme Court today has been grossly perverted. People say, well, Bob, if they're not following you today, why would they follow new ones you make? It sounds like a good question. It betrays a level of misunderstanding of what's actually going on today. Please ask me that question. Current interpretation allows runaway spending. You know all of these things. It's allowing complete abuse because of interpretation. If you ask any one of the 535 members of the United States Congress today, they're not going to tell you they're disobeying the Constitution. They're going to tell you they're following it. And they're going to point to the court. They're going to say, they said that's constitutional. Good question. Please ask me about that. Government right now is not operating in compliance. Properly written amendments can move us toward the point where our government would be in substantial compliance with the Constitution as written. Folks are afraid of a runaway convention. Ladies and gentlemen, what I would submit to you is that we have an absolute runaway federal government right in our face. We are staring down the gun barrel of a runaway federal government. It's actually a biblical principle. You know that it tells us in Romans that the government bears the sword. Today, look at it as being a gun. They bear the gun if we don't follow the laws. We're staring down the gun barrel of an oppressive, runaway federal government. And I think probably the differences between us, although Jesse's going to make an argument against what we're talking about, the differences really lie in when you and I look at what's happening. What do we see? Do we think we're going to fix it by continuing with the same old, trying to elect better people, more Republicans, more rhinos, right? And I'm with you. I'm not saying that we abandon that. I'm working with a candidate right now because I want to get rid of Senator Grant. We need to do that. What I'm submitting to you tonight is we need to open up a second front, a constitutional second front. We need not fear it. Don't wring our hands, crawl up in a fetal position of something bad's going to happen. They gave it to us. Those men gave it to us. Thank you very much.
What we'll do, folks, is after the Q&A, we're also going to leave Bob and Jesse time for closing comments, okay?
Lori, could you do me a favor for John? Sure. Can you just pass these things on?
Well, sure. I think Jesse needs an introduction. We all know Jesse.
I've got just so much ground to cover tonight, and I gotta say, Bob Menges, I'm not questioning your ability to hear from God, but when you said you weren't supposed to run for office, man, I think you should reconsider. I think you would be an awesome candidate, and really appreciate everything that you're doing. We do disagree, and it's only because there's let me say this. I said it to this group once before, that the truth is not afraid of an investigation. A legitimate investigation of the facts of the matter should only reaffirm its truthfulness. It's only lies that need the cover of darkness and silence. I encourage the debate, and I continue to ask the proponents of an Article 5 just to answer some questions that I have. To change my mind. And I'm open to being wrong. But until I have some facts that are presented to sway my mind, I'm not going to change it. Opinions are great, but it's evidence and facts, and really we have a responsibility to not follow men, not follow groups. I know that Glenn Beck, Mark Levin, all these other real strong conservatives, David Barton, all these powerful, amazing conservatives are saying this is what we got to do. But ultimately, we're not supposed to follow men. We're supposed to be following the truth, and we've got to follow the evidence wherever that leads. But I do know that the proponents of the Article 5 on the conservative side are extremely sincere, and I do not doubt that. But one of the things that I'm passing out to you right now, I encourage you just to read it later, because I'm not going to follow it per se. And I have this presentation, but it's more of a 45-minute presentation, so I might use it a little bit, but I might just kind of speak off the cuff here. One of the things that the proponents of the Convention of States project continue to tell people is that this is not a constitutional convention. The reason why John Bush Society calls it a con is funny, because a lot of proponents think that we are saying it as a negative connotation. It's a con job, con, something. Honestly, it never even entered my mind until that question was brought up. I just don't like having to say constitutional convention all the time. It's short for constitutional convention. That's the reason why we've said it historically. But when it comes to what they say, this is not a constitutional convention. I said, okay, well, is this the first time that Article 5 has been tapped and been looked at throughout history? Let's take a look. There's been a number of historical calls for the convention. As you can see up here, back in the the turn of the century, there's a number of states. It says 31 out of the 32 states. That's because Hawaii and Alaska hadn't yet joined the Union back in the 60s. There was a big push. One of the things I've got here, this is called a proposed constitutional model for the United States, for the new states of America. This was a project that, this product was at the end of a project that spanned 10 years period of time, and it cost $25 million and it employed 100 people. It was the Ford Foundation that funded this. Anyone know about how evil the Ford Foundation is? They're a major globalist think tank, but this is their new constitution. It basically changes our form of government where we have God-given rights. They turn it to privileges, and they totally get rid of the Second Amendment. What they ended up doing, this was no exercise in political theory, ladies and gentlemen. They intended on instituting this into our government. Right at this time, Nelson Rockefeller was vice president. He started pushing the states to basically call for an open convention so they can make the bait and switch. At this point of time, the conservative movement was very wise to go, hey, that's insane. We're not going to have a constitutional convention. You can't limit it. You know, why would we want to do that? And so they ended up doing, funding the Rockefeller Foundation, the Ford Foundation, the Brookings Institution, started funding efforts in the grassroots to deceive conservative organizations into believing that if they invoked the authority of Article 5 and to having an Article 5 convention, that they would somehow keep it limited to a balanced budget amendment. Since the players involved at this time, the stigma of the fact that, man, Article 5 convention, you can't limit those things. It was so damaging to the players involved. His career ended for some of the representatives introducing this. They ended up changing the name a decade later. There was a big push by the governor of, I think it was Utah at the time, back in the 90s, that it was called the Conference of States. And they say, this is not a con-con. This is not a constitutional convention. Oh, great, because you know what? We do have an out-of-control federal government. I'd love to be able to rein those things in and be able to limit the federal government. Who being a conservative would be opposed to that? I mean, honestly, if I knew there was a way to guarantee the limiting of a convention, we can get rid of the 16th and 17th Amendments. Gold. I mean, that's awesome. But when you realize that it cannot be limited, it becomes a very dangerous situation. But they swore this is not a con-con. So what happened was, whenever we'd ask them, okay, great, well, where do you get the authority for this convention? Oh, well, Article 5 of the Constitution said that upon the application of 2/3 of the state legislatures, Congress shall call a convention. Oh, okay. It's the same section that Rockefeller was saying, hey, we need to have a constitutional convention. Okay, where do you get the authority for that? Article 5 of the Constitution says that upon the application of 2/3 of the state legislatures, Congress shall call a convention. Convention of States, this is not a constitutional convention. It's going to be limited. And, okay, well, where do you get the authority for this? Well, Article 5 of the Constitution says that upon the application of 2/3 of the state legislatures, Congress shall call a convention. And so, we're talking about the same thing. I don't necessarily like calling it a con-con or a constitutional convention. Let's call it Article 5 Convention of States. Let's just, this is not a con-con, fine. Let's just call it a Convention of States, but let's look and see what is involved in Article 5. I'm going to skip a number of these, but the fear that a constitutional convention could become a runaway convention to propose wholesale changes in our Constitution is by no means unfounded. There is no effective way to limit the agenda of a convention. That's Professor Gunther. One of the most serious problems Article 5 poses is a runaway convention. There is no enforceable mechanism to prevent a convention from reporting out wholesale changes to our Constitution and Bill of Rights. History has established that the Philadelphia Convention was a success, but it cannot be denied that it broke every restraint intended to limit its power. Logic, therefore, compels one conclusion. Any claim that the Congress could, by statute, limit a convention's agenda is pure speculation, and any attempt at limiting the agenda would almost certainly be unenforceable. It is my firm belief that no single issue or combination of issues is so important as to warrant jeopardizing our entire constitutional system of governance. That's a Supreme Court Justice, Arthur J. Goldberg. This is a letter from the U.S. Supreme Court Chief Justice, Warren Burger, back in the 80s, who wrote a letter to Phil Schlafly explaining the very same sentiment. James Madison was questioned by, I'm trying to remember, I think it was Trumbull at the time, was a letter. He was being questioned, should we have another convention? It was the year after the first federal convention. This was his response. if a general convention were to take place for the avowed and sole purpose of revising the Constitution, it would naturally consider itself of having greater latitude than Congress appointed to administer and support as well as to amend the system. Having witnessed the difficulties and dangers experienced by the first convention, which assembled under every propitious circumstance, I would tremble at the result of a second. There is utter improbability of assembling a new convention under circumstances in any degree so favorable as those in which the late convention met, deliberated, and concluded. Hamilton. Anyone know who Gore Vidal was? He was a very liberal guy. This is what he talked about when it was concerning Article 5. He said, "It is a nice irony that the far right disguised as conservatives can take credit for so fundamental and radical an upheaval in order to balance by law the budget to put prayer to God in the schools or forbid abortion, pornography, and drugs. They have set in motion the great engine that will overthrow the very Constitution which they insist to be strictly construed." So let me say this. One of the proofs that we have, when it comes to the proponents of Article 5 convention, they say, well, the states are going to really be able to own this thing. They're going to control it. They're going to be able to the process for picking the delegates and whatnot. But there's a problem with that, is because in the U.S. Constitution, there's something that we know is called the necessary and proper clause. Congress is given a number of authorities in other parts of the Constitution, where essentially, they're able to limit appellate jurisdiction in the third, Article 3, and before they have some powers that they can work on. But also Article 5, they're to call a convention. And so, what happens when they're asked to call a convention? Congress is given the sole and express authority for the process of writing the rules for the picking of delegates, for the time that they meet. It is Congress that, under the necessary and proper clause, is because that Article 5 is one of the aforementioned powers, and the necessary and proper clause is applicable to. Anyone ever heard of the Congressional Research Service? The CRS, I'm going to skip through here. Oops, we'll go back. The Congressional Research Service was founded in 1916. Or it could be 14. But they exist, and the reason being is because a lot of these people that win the popularity contest, when they enter into Congress, they didn't really, they don't know what they're doing, and so they have all these issues come up. The laws come to the desk, they don't know what to do, so they go. There's a department that's created in the Library of Congress, and the first place they go when they don't understand what to do, let's say we have this Article 5, 34 of the states apply. Man, how do we do this? What do we do? First place they're going to go is the Congressional Research Service. And they supply, they're one of the most trusted resources by Congress to supply all the information that they need on to carry it out. This is what I have here is the document that they wrote July 9th, 2012, the Article 5 Convention to propose constitutional amendments, contemporary issues for Congress. In this document, when they're going to go, okay, Article 5 Convention, they're going to go in, one of the experts that they say, while the Constitution is silent on the mechanics of an Article 5 Convention, Congress has traditionally laid claim to broad responsibilities in connection with the Convention, including 1, receiving, judging, and recording state applications, 2, establishing procedures to summon a convention, 3, setting the amount of time allotted to its deliberations, determining the number and selection process for its delegates, setting internal convention procedures, including formula for allocation of votes among the states, and arranging for the formal transmission of any proposed amendments to the states. This is what Congress is going to go look at. This document, when they're called to call this convention, this isn't the Jumper Studies opinion. This is the Congressional Research Service's opinion. That's where they're going to go when it's time to call a convention. So it's important that we understand that under the necessary and proper clause, if you're a constitutionalist, you have to follow the Constitution. And Article 5 being one of the aforementioned powers that necessary and proper clause falls under. It is Congress that is given that sole authority under the necessary and proper clause to write whatever rules and whatnot to apply. One of the things that the convention states, man, this is going to be limited. How much time do we have?
You have 8 more minutes.
Okay, they said this is going to be limited, and let me tell you why. There's whatever delegates that are going to go in the state applications, we're going to charge them with a felony if they try and go wayward from what they're doing. And so one of the documents that I was given by Representative Bill Taylor that he's touting around as you know, his gold standard for you know, why the convention states is the way to go is document 10 myths about a runaway convention. And one of the statements he talked about that it's most likely this federal convention is going to be modeled similarly after the state conventions, constitutional conventions, and that's accurate in the sense of anyone know what the first order of business was for our South Carolina constitutional convention a few years back? Anyone know what the first thing that happened was? It was the Supreme Court sitting Chief Justice of South Carolina that got placed as chairman of the convention. Okay, and so if the first order of business that we're going to have at a federal convention is to place its attacks John Roberts as chairman of the convention, whatever happened to the notion that we're going to check the overreaching power of the judiciary. If the first thing that we do is place John Roberts as the chairman of the convention, they're going to read these applications for this convention. And they're going to say, okay, well, look, there's 34 applications here, but there's 16 states that got drug here kicking and screaming. They have to be here. And so what do those other 16 states have to do? Anyone think about that? Are they limited to such felony charges and whatnot? You know, in reality, you know, Article 5 is the supreme law of the land, the Constitution. You know, as this chairman, he's going to say, look, you know, I know you have these felony charges, tar and feather clauses on you if you go away, but there's 16 states here that don't even have anything there. Let's get down to business. You're not going to be threatened with a felony if you're here to do the work. So when it comes to ratification, though, it's important that we understand, they say, look, it's going to be limited because this felony charge, that's going to be thrown out the first order of business. But if for some reason it went away, it was a runaway convention, 38 states, man, have to ratify such a change. So, I mean, Mississippi, Alabama would have to ratify getting rid of our guns if it ran away, you know, get rid of the Second Amendment. That's a fail-safe. You know, so we might as well just have this thing because, you know, if it got crazy, we have enough conservative states here that it's just going to totally be able to safeguard us. Well, the only precedent that we have for a general federal convention is our first, 1787 was our first convention. What happened? Anyone know what the requirement for ratification was in the Articles of Confederation?
Yeah.
All the states.
13 states. 13 state legislatures.
Yeah.
Key point.
All the states.
13 state legislatures. Make sure you tell them that.
Hold on. All the states were supposed to ratify this convention. Okay. And what happened at the convention? Well, about 13 delegates resigned in disgust. Lansing and Yates wrote a long letter to the governor of New York saying that, oh my gosh, they're going way beyond the dictates that we thought we were going here to do. I can give you the letter. It was clear that they did not want to stay and play the game of access. But what happened? The convention continued in their absence. Okay, and this is what we got. And so they changed the requirement to 3/4. Why? Because North Carolina, Rhode Island, we're not doing this. Rhode Island actually voted no 4 times to actually call a ratifying convention. Michael Ferris, head of the Commission of States Projects, is saying, no, listen, that requirement for all the states to ratify the convention was satisfied upon the application of them calling for a ratifying convention. Okay, well, let's look at the dates. The first time that the Rhode Island, the new government met March 4th, 1789. Okay, new government met after the convention. We're working. This is the government's in play. But when did the last state ratify or even call for a ratifying convention? It was January 17th, 1790, the next year. It is a fact, ladies and gentlemen, it is not an opinion, that the first convention changed the requirement for ratification because the new government met March 4th of 1789. Rhode Island didn't even call for a ratifying convention. They voted no 4 times. They didn't even call for a ratifying convention until January 17th, 1790. Okay, so am I an extremist to think that the only precedent that we have is that they changed the requirement for ratification before? Am I too extreme to believe that if that's our only precedent, that they changed it before that the possibility exists they could do it again, especially if they got rid of our Second Amendment or rewrote a lot of the Constitution. It's important to understand that the far right is not the only ones calling for a convention. It is well known that anyone know about the Young Turks? The Young Turks are like the Glenn Beck of the left. They just founded Wolfpack. Guess who funds Wolfpack? George Soros. He funds almost every other left-wing, far progressive group. Wolfpack aims to lobby state legislators to have an Article 5 Convention of States to restore democracy and free elections. They want an Article 5 convention as well. So Soros is actively funding the far left groups. And I know that the Convention of States, Michael Ferris is telling mistruths about saying the John Birch Society is claiming that Soros is funding the Convention of States, and that has not once been uttered by anyone on our staff or any of our articles. But they are funding the far left. And so the Atlantic, liberal rag, wrote back in 2013 November issue, the U.S. needs a new constitution, here's how to write it. They go in, oh, it's so outdated, we need a new constitution. And they said, our solution, Article 5, Convention of States. The
2 minutes.
Okay. It's important to understand that one convention, that was a ratifying convention. It's important to understand what happened in Utah. When they wanted to get rid of prohibition, right, the 21st Amendment, they were having a hard time with Utah. There was a lot of Mormons there, okay? It was a dry state, and not a single legislator wanted to ratify the 21st Amendment to get rid of prohibition. But the boozers, the liquor industry, along with Congress, sought to get their way no matter what. Even though it was a very conservative state and they did not want a liberal or sinful or amendment passed in their state. They said, there's no way. What did they do? Congress had them have a ratifying convention, all right, to ratify their new document. And so guess what happened? The 36th state to ratify and get rid of prohibition was Utah. The dry state that not a single legislator wanted to vote for it. But they had a ratifying convention. Guess how they got that stacked? So the idea that somehow, whatever gets passed, it's going to be, we have conservative red states. Well, let's look at the states real quick. Last thing I'll say is the proponents have done a real good job of autonomizing the states as like this descendant Superman angel, like, come on here, fight the federal government. Oh my gosh, the states. Well, let's look at the states. Right now, Representative Bill Taylor, the proponent of this bill in the House, is not even a co-sponsor of the legislation in common court. He came up to me, he was trying to get me an A. He didn't know I was against the Article 5 convention. He said, Jesse, I want to talk to you about this, but I said, where are you out of common court? He said, well, no, I'm a first vice chair of the House Education Committee, but I haven't I have co-sponsored that. It's been in there for a year. Tea Party Taylor, that's going to fight the federal government, take the power back, won't even co-sponsor the bill to stop common core. And he voted to expand Medicaid, or was signed on to a bill to expand Medicaid the day after that he voted to nullify it in the House. His reason why? Oh, I didn't read the bill. Well, hopefully you'll read the amendments at a convention. That's all. I've got a lot more. But anyhow, there you go.
We're going to open up the questions. You've obviously heard two very strong arguments on the pro and con here with two very learned, passionate men. I know one thing for sure. None of us is as smart as all of us. So with that in mind, with the utmost respect, let's take questions. Aim at me. We'll give each presenter here an opportunity to respond. First question. Rob.
Why is Jesse wrong?
That's a great broad question that lets me reply. Awesome. One of the things that Jesse, most of the documents that Jesse holds up are modern documents. He goes back and quotes some of the guys, but what I brought to you tonight and shared with you are the founding documents. I'm a historian, I'm a constitutionalist. I bring to you Madison's effort. Let me just say this. On the flyer that was sent out, it says that today it's a convention of states. I was hoping maybe somebody would ask Jesse this question. I'll go ahead and give it to him. But people say that we're calling it a convention of states today. Whoever made up the flyer, no matter whether you agree or disagree with me, we're not calling it a convention of states today. Does anybody know where that came from? Did we just make it up? Did we make it up? I'll tell you. In Virginia, the very first state to call for an Article 5 application was May 5th of 1789. And if you read the Virginia resolution, it says that they're calling for a convention of states. It's not a modern term. If we're going to be constitutionalists, whether we agree or disagree, we need to use constitutionalist terms. The other thing I would say is this, just in my 3 minutes here, Jesse held up a lot of documents. I was glad to see him hold up the one by Chief Justice Warren Burger. One of the things that the John Birch Society uses to make their argument is a letter written in 1988 by Chief Justice Warren Burger. Can anyone in here tell me what they think is the most egregious Supreme Court decision in our nation's history? Roe versus Wade. There are 60 million unborn babies crying today that were butchered. Guess who wrote and signed on to the majority opinion, the most activist liberal judge in our nation's history was Chief Justice Warren Burger. Chief Justice Warren, if you don't agree with me, make sure you go out of here. Don't use Warren Burger's letter anymore. Because if you grieve for the unborn, if you understand that Chief Justice Warren Burger, you want to talk about perverting the Constitution, he said that they found the right to butcher unborn children in the penumbras of the Bill of Rights. Now, my students can tell you, I'll just tell you, penumbra is a shadow. Chief Justice Warren Burger is not going to write a letter endorsing something that is going to curtail and strip him of his engaged federal powers. So those are some of the things that are held up, and they continue to put it up. And I don't know why they do it. I would duck and run from Warren Burger. Use the other arguments, but don't use Warren Burger.
How do I respond to the question, how's Jesse wrong?
I guess you need a new one. You need a new question.
Well, one of the things that he talked about, as far as, I wasn't illustrating the different terminology, I'm not saying that it's not appropriate to call it Convention of States or whatnot. I'm just saying that there's been a lot of different titles given.
Well, all I was suggesting that when you put out a flyer like this, you get historically accurate. It says today they call it a Convention of States, and your organization has said that.
Sure. And it basically, I'm just illustrating the fact that there's different terms that apply to the same exact section of the Constitution, Article 5. Constitutional Convention, Conference of States, whatever you want to call it. But it talks about Madison. I think it's important. I'll just say this out of the gate: is that if this is the break last when all else fails, everyone remember the Alien Sedition Acts of 1798. 1798, it was law. John Adams signed the law. It was a criminal offense for anyone to criticize a government official. You couldn't criticize a congressman, you couldn't criticize the president, but you could criticize Thomas Jefferson, who was vice president at the time, and an opponent of the Sedition Acts. So, they actually arrested Benjamin Franklin's grandson. About 25 people were arrested, newspaper editors, and our founding fathers, James Madison and Thomas Jefferson. Oh my God. The First Amendment, come on. I mean, you can criticize whoever you want. You can't threaten them or so on. But what would they do? I mean, can you imagine, John, that if you criticize Obama, they come and shackle you up? Would you say that's an out-of-control federal government?
Oh, yeah.
A runaway, totally out-of-control federal government? Well, it's interesting their response. It wasn't oh my gosh, they're breaking the Constitution. Let's get together and amend it. No. What did they say? The proper role, Jefferson said, was in Kentucky resolutions. He said, anytime the federal government assumes powers not delegated in the Constitution, a nullification of the act is the rightful remedy. It's important he just called it an act. It's not law. You don't nullify a law. It has to be constitutional. Right? Madison went even further in the Virginia resolutions. He said that in case of a dangerous, palpable, and deliberate exercise of other powers not granted in the said compact, the states have the right and are in duty bound to interpose for the arresting the progress of evil. His response to the out-of-control federal government was, let's get together in a minute in a convention. No, let's just nullify. Let's just interpose and consider it a usurpation. You know what? They won. We can too.
Property of Florida. Yes, sir. What's your name? Hey, David. What's your question, buddy?
Do you believe that the federal government respects the states the way that it did back then?
Gosh, I think it's always disrespected the states. And that's why our founder said we should jealously guard against.
Can I refine that?
Yeah.
Do you think that the federal government back then was very weak, even after the Constitution, because it didn't have a big military or anything like that, correct?
Compared to its size, of course, yeah. I mean, it's much smaller, dramatically.
Do you think the federal government today, with everything it has, military and all that, respects the states to the degree that they did back then?
No.
So how will nullification work there?
Well, it's going to be a real problem.
That's my main question.
No, definitely. There's a real problem there because one of the biggest problems, I think, is that we've superseded the state militias. Because sovereignty is predicated on our ability to defend it. Okay, and if the federal government has all the guns, that's dangerous. But it's important to understand that one of the 10th Amendment reserved powers, whether you want to call it nullification or anti-commandeering, it was already upheld by the Supreme Court. Mac Prince versus U.S. A case back in 1997 established a long-running precedent, most recently upheld in that case. The U.S. Supreme Court ruled that federal government cannot compel or commandeer the states and to implement federal law that they using their own treasury and resources. This was in response to the Brady bill that Sheriff Mack sued against and won. And this is the dirty little secret that the federal government cannot do what they want to do without the states doing it for them. And so the exchange is we always give up our sovereignty for the money. Common Core. Hey, you want these standards? Well, here's $6 billion. And so you have this. And so I think that the proper role is to the 10th Amendment. Honestly, the states have all the power, right? In this time, regardless if we have the guns, because the Supreme Court. I mean, what are they going to say about? I mean, they're going to go back on Prince. It's already established case law, and so I think there's a long-running precedent there for the states to push back in an effective way. And,
yeah, I'm gonna. It sounds like the question is, either or, notification or convention of states invoking Article 5, and so I'll address that. I don't want this to be. This shouldn't be that because I support what Jesse's been doing with nullification, but I support it for different reasons. So I think it would be instructive for me to answer that question because it goes to the fact of why I think Article 5 is the proper way to go. And I will just encourage you, go to Madison's letter and written in. Let me finish my 3 minutes. In 1830. Where he wrote back to somebody that asked him, the winds of secession were whipping up in the 1830s. I told you Madison was one of the longest living guys, and people were writing him left and right. What about this stuff of nullification that you did in 1798 with Jefferson? Because Madison authored the Virginia Resolution, Jefferson authored the Kentucky Resolution. Jefferson did say what Jesse said, he's got that right. In 1798, what was the relationship between the states and the federal government? Virginia was one of the most powerful states. The federal government was 12 years old. It wasn't even a teenager. It had no means to shut down what Virginia would do if they nullified. The federal government was the size of a pea. And this is 2014, so I'm here to give you a reality check. I support nullification because I want to poke my finger in the eye of the federal government, and I'm behind them 100%. I'm not just saying that, I'm with them. I want to do that. But I do not believe that nullification is going to stop the federal government. The federal government today would squash South Carolina like a grape. And if you question that, if you think I'm wrong, like Jesse intimated a while ago what he said, he doesn't think that'll happen. Who lived through the era of George Wallace standing in front of the door of the University of Alabama? What did the federal government do? As wrong as Wallace was the federal marshals came in and they picked him up and they moved him. Nullification today is not going to stop Obamacare. We must roll back federal power. Again, I'm for it. I want to stick my finger in their eye. We've got to understand what's going to do what. I think, and I would encourage you to go to this because Madison, let me finish that. Madison's in his letter, he answers, he's asked about nullification, and he says, we can disagree, but it's right there. Don't take my word, don't take Jesse's word. Please read Madison's word. He said, we were taken out of context. We never met. Madison says in here, he says in here, that if a single state could void a federal law, the Constitution would be useless. His words. Go read them. Don't take my word for it. You don't have to like what I'm saying. I'm just telling you, that's the facts. The way to curtail the federal government is teeth back in the 10th Amendment. The 10th Amendment has no teeth in it today. The way to do that is read the Liberty Amendments by Mark Levin. There are amendments in there. True nullification. One of the proposed ideas by Levin is where 3/5 of the states, that would be 30, 3/5 of the states could void a federal law within 2 years of passage. There's real true nullification right there.
Next question, Leanne.
Okay. I think it's really interesting that you said that the 10th Amendment is being ignored. Because even if we do have a Constitution of States, who's to guarantee that that's not going to be ignored either if we succeed in doing what you're proposing that we do? I want you to tell me how you are going to guarantee that those who are not trustworthy in our Congress are not going to be, when they call this convention of states, are not going to be in control of appointing the delegates. We already see today, even in
A couple
our
of
own
questions there, so I'm trying to track them. There's 2 questions there.
That's enough.
Okay.
2 questions, I'm trying to track them. There's 2 questions. The first question is, if they're not following it today, why would they follow new amendments? Your second question is how do we know the federal government, the Congress won't take control of delegates? The first question. Its question is asked all the time. With all due respect, it betrays a misunderstanding of what's happening today. And the reason I can prove that to you is because modern amendments are followed 100% of the time. One of the things that I teach in my course to the high school kids is the 2 most perverted portions of text in the Constitution are the Commerce Clause and the General Welfare Clause. They've been stretched, pulled, twisted, and perverted for 80 to 100 years. The court is not reading original intent like I teach today to my students and other originalists like you all do. They're interpreting a Constitution based on all this twisting and contorting. But the modern amendments, ma'am, I would submit to you, can you vote today? You can vote today because of the 18th Amendment, which is a modern amendment that is followed 100% of the time. The 22nd Amendment is the term limit for the President of the United States. It is followed 100% of the time. Every one of those modern amendments is followed to the T today because they are crystal clear language and there's no way around them. The General Welfare Clause, the Supreme Court has tortured. Justice Roberts just did it with Obamacare. And it's right there, and it tells us right there. In other words, I can tell you, my students can tell you tonight what the original intent is of the General Welfare Clause, because if you go to Federalist 41, again, not a modern document, go back to what they said. Madison explains in detail. So the court can do that, but they don't do that anymore. So it's, that clause would need some clear, crystal clear language that could be accomplished that would roll them back. Your other question was, how do we know that the Congress won't appoint the delegates? Well, the only thing I can tell you, and Jesse can't tell you really any different, is that we can only go by history. And the history is that never in a convention has the Congress appointed delegates. Only Article 5 says that they shall call a convention. Every time there's been a convention, there's been many, over 30 conventions held prior to the Philadelphia Convention. The states appoint the delegates. If the states file for an Article 5 application and Congress steps in and says, this is our baby, the states are going to exit. I can tell you that. In other words, one of the guys in here drew up a matrix for me. I mean, you can disagree with me, but right now 27 states are controlled by Republican houses and Senates and governorships. The Constitution, as my friend Brian Kelly tells me, the COS is our playing field today. If we mess around, wring our hands and wet our pants and go into a field position, we're going to lose this opportunity. Even though we have rhinos and we know it, I would rather influence Columbia than try to influence Washington, D.C., who could care less what I think. You and I have a much better chance of influencing Columbia with a set of delegates. They will choose those delegates. And I go back to this again, this whole idea of the Congress taking over the Federal Convention. Why would they do that? They can propose amendments right now. If they change the amount, and I hope somebody will ask me a question on the original convention, because Jesse, with all due respect, he was historically absolutely wrong on his description of what happened in Philadelphia with that convention.
Good time for you, Jesse.
Okay, sure. I encourage all of you to go back, Google Lansing and Yates delegates from New York, letter to the governor of New York. You can see for yourself. It's not my opinion. Again, the fact is that they were disgusted with the progress of that convention. I want to go back to one thing he said about Madison's notes on nullification. What James Madison, in that same letter that he's referencing, it's important to understand that when he was talking about the Constitution would be of no effect if once they could make null and void a federal law. He was referring to Calhounian style nullification. Calhoun was insinuating the idea that if one state nullified it, then essentially the rest of the states it's going to be null and void almost anywhere. He also said in the same document that he does not deny the natural right for any one state to nullify. Read the document. I encourage you to go back and read that letter. It's in there, right? And so it's important that we don't handpick the text that supports our own idea.
No, read the whole thing. You'll see what he says about that. What he meant about that. Read it. Don't take my word for it. Read it.
Please do. When it comes to again, and your question about who's going to control this, I think I made the case pretty succinctly. About the Congressional Research Service. I would prefer if if this Article 5 convention was to take place, that after they petition Congress to call this convention, I would love for them to pick up the phone, Congress, and call Bob Menges and ask, man, what do we do? We never have one of these. I would love if they did that. But who do you think they're going to call? The Congressional Research Service. And what did they say? Well, they have historically claimed that it's they, under the Necessary and Proper Clause, that have the sole authority for the process of picking the delegates. And again, when it comes to Congress getting their way, let's just imagine for a second. I know that the temptation is there. It's a silver bullet. Man, we just have this convention of states, and all of our troubles go away. But do you think the far left groups let's just remember who's way better at organizing in the grassroots. It's not the newly awakened Tea Party.
I will agree with
group.
that.
It's the far left. It's the liberals. We had dueling rallies at the State House. First day of the session this year, I had a banner it was like, printed up from Staples, 3x5, looks pretty slick, it was on like makeshift poles, and a guy holding an umbrella, Jerry Ziegler, thank God for him, wherever he's at, that was holding an umbrella for the president of Freedom Works that we had come speak to nullify Obamacare. But the other side, the ones that want Obamacare, they backed up like this massive truck, and they dropped like a portable stage. They're professionals. I mean, they know what they're doing. They've been doing this for a long time, and they're oozing at the opportunity to have, like Gore Vidal said, have these conservatives tee it up for George Soros to fill us full of arrows. Bill Ayers, just about a month and a half ago, was in a debate. It was on C-SPAN with Dinesh D'Souza. They were asked about the Convention of States issue, and Dinesh said, "Hey, look, why don't we try enforcing it, instead?" And he had it right, but Bill Ayers said, guys, it's been far too long since we brought this up. We absolutely need to have an Article 5 convention because, look, our Constitution's antiquated. There was a woman, December of last year, just a few months ago, she was a professor from Texas, gave a speech up in Connecticut. She said, man, all these mass shootings are a real problem. It's just, we've got to do something. Is it time to have? Okay, oh God.
Gotta do something, period.
Yeah.
Young man?
Was the Constitution
Stand up and let's hear you loud, buddy. A big guy like you, let's hear it.
Was the Constitution illegally adopted?
Yeah.
That's the question. Kyle's asked me that question one of my students, because we actually have a chapter. We have a chapter in the book. I didn't plant that, but I asked somebody to ask it. I just did it out loud because I wanted to go there, because we have a chapter in the book. That is the core, really the core difference. When you hear con and fear of a runaway convention, it really goes to what happened in Annapolis and in Philadelphia. Okay? In the 3 minutes, I'm going to try to give you a quick history lesson. 1781, Cornwallis surrendered. 1783, the Treaty of Paris is signed. Okay? They're under the Articles of Confederation since 1778. Okay? The Articles of Confederation are an utter failure. I don't think anybody disagrees with that, although what we see today we know is a problem. But the Articles were, the 13 states were coming apart. They were warring economically. Great Britain is across the ocean, ready to come back and take it back. Does anyone here think that we won the Revolutionary War by military prowess? We did not. We won it because of the providential hand of God. Whether you believe it, whether they're Christian or not, that's how we won it. So here's what happened. Don't take my word again. Go to the source documents, okay? Not the modern trite that people, not Jesse. I mean the other arguments that are made by these other organizations. Didn't mean that. These other organizations, I consider some of that stuff trite because I'm a historian. Go to these documents. In Federalist 40, for anyone that thinks that the original convention was, as Jesse described to you, as a runaway illegal convention, which to me is illogical for someone that's a constitutionalist. Because if it was runaway and illegal, what are we doing defending it today? It wasn't runaway and illegal. And in 1786, they met at Annapolis to try to amend the Articles. 5 states showed up, not enough. So what they did was they said, can we get a call to the 13 states again for another meeting next year in May? So 7 states made a call to the 13 states to meet in Philadelphia in May of 1787. And that call is, Madison records it in here. Here was the call, for those of you that talk about the runaway con and the revising the Constitution and the Articles where they were trashed and we got a new Constitution that is absolutely historically inaccurate. The charge that went out to those that went to Philadelphia was this, and I quote, "Render the Articles of Confederation adequate to the exigencies of the Union." They used an old term, exigencies. It means emergency. There is an emergency in the Union. Render them adequate. They didn't say make 1 amendment or 50 amendments. They said do what it takes to save the Union. Matter of fact, if you read the rest of that quote, it says to preserve the Union. So that's what they did. I asked my daughter this the other day. We're just having this banter back and forth. I said, if we have a club and we have bylaws to the club, and I say they're not working, go amend them. If you come back with 1 amendment, did you amend it? Yes, sir. If you come back with 20 amendments, did you amend it or did you change it? I still amend it. If you come back with 50 amendments, did you amend it? We still amend it. Yes. People say that it's a brand new document. The United States Constitution was a title change. Madison explains it. Not my words. Go to Madison. Federalist 40. Write that down. Complete defense of what happened in Philadelphia. If you think Philadelphia is what Jesse said, you're at odds with James Madison. It's beautifully laid out in Federalist 40 what the Philadelphia Convention did. And then they said, and Jesse was right, the article said that 13 state legislatures must approve of any changes that come out of Philadelphia. That document got transmitted to the 13 legislatures. It didn't get transmitted to the conventions. To Jesse's credit, he did explain that. He disagrees with it. Is that time up? 3.5, sorry.
No, it's important that we understand that although certainly some of the states, and Madison, a major Federalist, he believed that this is proper. He liked the product of the Constitution, but you got to understand. I think there was at least.
Do you dislike the product today? I'm just curious.
No, absolutely not. I'm going to get to that.
Oh.
Bob, let me speak. When it comes to whether or not 13 delegates resigning from the convention, it's, I think, fair enough to say that not all the delegates there felt that it was fulfilling what they were going there to do. Okay, when you have delegates that resign, right, and you have the letters, historical documents that talk about exactly what was going on at the time, there's an overwhelming amount of proof. And again, I'd be happy to provide all of that for you. Afterwards, I can give the documentation. There is definitely at least a disagreement on as to was everyone thought this was good? Well, no. There was a number of delegates that resigned and discussed. And so, when it comes to do I think this is an illegal constitution? No, because there was a federal testimony.
So what is the argument?
Wait, no.
I don't understand the argument.
Please,
He
Go ahead.
doesn't interrupt you.
That's true.
When there was a federal testimony, a subcommittee on the Constitution of the Committee on the Judiciary of the United States Senate. This is a quote from that hearing. I am, however, totally opposed to any measure that would encourage the 50 states of our nation to amend our national constitution by means of the convention method. For I, better than most, appreciate the hidden dangers inherent in the system. I do believe that any prior law, no matter how carefully drawn, cannot inhibit or restrict or delimit a constituent assembly once it convenes. Of course, those initiating the convention would say, but its field of legal operation is limited. We have said so. My contention is that it cannot be so limited. At the moment a convention is assembled and sworn in, it becomes a self-directing body with only such limitations as prudently places upon itself, and the prior constraints which have so carefully been placed upon it no longer apply. That was James Mechner. He was the secretary of the Pennsylvania Constitutional Convention. That was back in the 60s, this convention. So, and a parliamentary body becomes its own sovereign entity, right? So they have the right to change the ratifying method whatsoever. When they enter into that, okay, they can change your ratification because it's a parliamentary body that is not so, as he eloquently stated before this committee in Congress, that it's not going to be limited. So again, I am a strict constitutionalist, and just so you know, the John Birch Society has been like the Jedi Force of defending the Constitution since the 50s. And you might think, well, I thought you guys were like the evil organization. Well, that's why, because we've been defending the Constitution so much, and the enemies of our Constitution have been so great. So they said, we've got to stop the John Birch Society, because they're doing stuff, and they're actively teaching people the principles that made our country great. And so to insinuate that we don't respect the Constitution is just, if you're just ignorant of who the John Birch Society is and was. And so I'm only here, and again, I'm all about stopping the federal government. I'm considered a right-wing extremist by most, in the sense that I'm a states' right guy, a sovereignty, and why would we think it's the right way to, the real 10th Amendment stuff is we're going to strengthen it by making us more a sovereign state dependent on 2/3 of the rest of the states to do something? If a sovereign state is sovereign, why should we have to wait for Connecticut, New York, and California to get their act together? We have a right now to say no to the federal usurpations.
To now would be the balanced budget amendment. I am confused as to if you got what you wanted, if you could have anything, what would be achieved other than a balanced budget amendment? And it seems as though we could have a balanced budget amendment in the same way that I got to vote. That allowed women to vote. Why couldn't we have an amendment? If that's the main reason to have a convention, why couldn't we just do it in the traditional way?
Okay. Number one, how's that working out for us right now to get that balanced budget amendment from any Congress in the last 20 years? Does it look like it's on the horizon to anyone in here? Anybody think they're going to do that? Anybody think the federal government's going to impose term limits on themselves? Let me tell you something about term limits, and back to the thing about the amendments. The balanced budget amendment would be probably a good idea. Balanced budget amendment, let me explain something to you. Balanced budget amendment could be the most dangerous amendment ever put forward if it's put forward alone. Because Congress can comply with a balanced budget amendment simply by raising taxes. It can lead to the largest tax increase in our nation's history. If it is not accompanied by amendments that restrict and shackle, put them back in chains like our friend Jefferson did. I think we're both like Jefferson. Put them back in shackles if we don't do that. But let me give you term limits, for example. 75% of the American public wants term limits. I think the lowest count is about 60. Pretty good cross-section of the American public wants term limits. I'd say even there's some liberals that want it, but whatever. But we want term limits because these guys, and I ran a race, I have run a race last year, I can tell you the power of incumbency is off the chart. That's when Lindsey Graham's $7 million, he's got all the people that are afraid to give anybody else any money because of that. You know this back there. It's hard. Lee's having a hard time. All these guys are hard time getting, all of them are having a hard time getting money. But here's this. Does anyone think that the federal government, the United States Congress is going to do that? You said no. They're not going to cut their own throat. The only other avenue to term limits is the first mode of Article 5, whereby 2/3 of both houses of Congress. 23 states have passed term limits amendments. The United States Supreme Court has struck them down. I'm going to tell you a fact. No matter where we come down, we can't disagree on this one. The only path, if you want term limits, remember the Supreme Court has struck it down. It says it's uncon. Because the way we got presidential term limits was how? 22nd Amendment. Okay? The only vehicle, the only avenue, the only way to get term limits on these charlatans that are up there is via an Article 5 Convention of States. You can disagree with me on what you don't like the Article 5 Convention. If you want term limits in here, I just gave you 2 facts. The federal government will never do it, ever. They're not going to cut their own throat. The United States Supreme Court has said the only way to get term limits is via an amendment. So, that's the answer to your question. But the only thing, if I've got any seconds left on this thing. Okay. The other amendments I would refer you to, and again, I'm not preaching Mark Levin, his book, because that's not really connected to ours. Mark Levin wants any organization, there's 3 or 4 organizations trying to push for a convention of states. Ours happens to be the one that has that's building a grassroots machine nationwide. But in his book, he has 11, I think, pretty good proposals. I think one of them would not be germane to our stated call. And our stated call is that the bill we're getting introduced in every state right now, 11 states have introduced the bill. Georgia has already passed it. The application is done. Is to limit the power and jurisdiction of the federal government. Therefore, only amendments that are germane, I know that he disagrees with me, but only amendments that are germane to that. We think from history and from the courts, matter of fact, Michael Ferris is one of the only lawyers, he's one of 4 lawyers that have ever argued an Article 5 case before the Supreme Court. This is one of the founders. He has argued 9 cases and won 7 before the United States Supreme Court. He's a brilliant constitutionalist. As we speak tonight, the big dogs are debating too. And the JBS in Oklahoma and Michael Ferris are having a debate tonight also on this. Matter of fact, the John Birch Society, in one of their letters, I have it right here, called Michael Ferris a brilliant constitutional scholar several years ago. They don't think he is today. And by the way, I don't think bad of the John Birch Society. I'm a little perturbed by some of what I think are twists of history, but they have stood strong. My question would be, what has all of that education done for us? And I'm about education. I give up one night every week to do it for 15 years for young people. I'm for it. I'm with Jesse. But it's not working.
I think we got big dogs here.
When it comes to, and unfortunately, Michael Ferris hasn't returned the favor to JBS. He recently on a conference call called the John Birch Society an evil organization, and that is an enemy of the Constitution. So just so you know, we're not playing that kind of game. But when it comes to the amendments, when it comes to term limits, anyone know that was in the Articles of Confederation, and our founding fathers found it as a defect. They said, this is good. It was, each congressman was supposed to serve 1 year. The Governor Morris, the Pennsylvania delegate, said, imposing ineligibility tended to destroy the great motive to good behavior, the hope of being rewarded by a reappointment. And Alexander Hamilton on Federalist 72 said a comment on term limits. He said, nothing appears more plausible at first sight, no more ill-founded upon close inspection. Why? You think, well, man, you're looking at the current crop of legislators and I agree, man, let's get these bums out of there. We don't want them. But term limits is only solving a fruit issue. It's not laying the axe to the evil root. Let's just play this down the line. What if we finally worked real hard to educate the electorate, and we finally got a stronghold in a community or a state where we're electing this, Trey Gowdy's, Mick Mulvaney's, Tim Scott's, and we spent all this time and energy and effort, and all of a sudden, hey, your term limit's up. See you bye. There's a number of constitutionalists that, U.S. history, that would have been really unfortunate. they had a real stronghold there. And when they were delivering the goods, they were answering their promises, and they were good men of character, they had a stronghold. They didn't even have challengers in their primary. And so it's like a gold state. Out in Texas, there was a congressman that was like that. And thank God he served for many years. And I hate to see it have been cut short. And so I always say that, and I used to think about terminalists, man, that'd be great. But it's just because we don't like the current crop that's there. But what if we finally started to educate people enough with the truth, and we finally started getting some good guys in there, and then you're in a perpetual election cycle. You're in a perpetual campaign because our good guy's gone, and then now I just got to work for the next good guy, and it's like a perpetual campaign. Are you kidding me? Why don't we work on educating the local community on the principles that made our country the envy of the world, and then we have a representation. Our congressmen, the representation that we have, you guys, is only the fruit of the people. Thomas Jefferson said that the only way that we're going to maintain our freedoms as a nation is to have an informed and involved citizenry. Many, many quotes about education is the only way. Because why? Because ignorant people are easily enslaved. And until we do the hard work of having to educate each other, I'm not talking about the masses that can be like hopeless. Like, oh my gosh, have you seen TV lately? Some of these people out there? No, I'm not talking about them. History's not shaped by the majority. It's the impassioned, irate minority. Our side just needs to be a little bit bigger about defending our liberties, and the other side is about taking it. Once we start to build enough of an informed electorate, not enough, right? Not the majority, but enough, then we can have that reflection in Congress. And again, there is no silver bullet. I wish there was. If this convention could be guaranteed to be limited, then why wouldn't we? Of course. But I think I've brought up enough evidence to the fact that there is no effective way to guarantee the limitation of the federal convention, especially when you have the far left, that woman that I was talking about. Yeah.
Would you permit the chair to ask a question?
Can I just ask, does that mean you're on record you're against term limits, right?
Yes. Oh, yeah.
My question is this, guys. I agree with both of you, what you've said, that God had his hands on the creation of this country and on the brilliance of our forefathers, and that with kings and dictators and man ruling man after 5,000 years, we finally acknowledge God is our creator and our rights come from God. Where we are after 60 million abortions, kicking God out of school, on infinitum, do you think God will have his hands when providence prevail in this state constitution?
You mean the convention of states?
You mentioned the states.
If I didn't believe that, I wouldn't be here. I would tell you that, on that flyer again tonight, if I believed everything on that flyer, I would be standing right next to Jesse railing against this thing. Okay? The founders, there's nothing was sure. The founders said they were pledging their lives, their fortunes, and their sacred honor. Many of them gave everything they had. It wasn't a sure thing what they embarked upon. Nothing's a sure. I'm not standing up here. If anybody thinks I'm standing up here telling you this is a silver bullet, you're not listening to me. This is not a silver bullet. It's not going to be easy. It's going to be extremely difficult because of that 38. The founders intentionally made it very hard to amend the Constitution. And they were right. They didn't want it done by wind. This is going to take a large-scale effort of a lot of conservatives coming together, recognizing, and then using the power of that aggregation to hold these guys' feet to the fire. And I would just tell you that nothing's a sure thing. I would say that the possibility, and we'll agree to disagree at the end of the night, the possibility of my studied, somewhat expert opinion, for whatever that's worth to you, and I've studied this a long time. I've read the founders intensely. Okay? That's my thing. I'm a geek on that stuff. I love it. If I could transport back in time to the colonial area, I'd go in a heartbeat in a machine, as long as I could take my AR-15 with me. Okay? But here's the deal. Nothing is a sure thing. I would say that the chances of a runaway convention, what has been described here, is somewhere between extremely remote and impossible. But nothing's impossible, so it's north of impossible and extremely remote. We'll disagree on that, but what I'm saying is that all the things that we've tried to do, all the things, we don't have time to wait. I guess that's the fundamental difference between us, is what are we looking at in front of us? I think what we're looking at is Rome is on fire. It's not the Constitution that's on fire. Rome, our country, is burning down, and we don't have much time. But yes, if I didn't believe it, I think that God has to be with us. I can't speak for God, like when they asked Lincoln that question. Our prayer is, and we have prayer warriors, that God will find favor with what we're doing.
When it comes to God blessing such a convention on a federal level, I don't think so, because we don't deserve blessing on a federal level. I believe that we deserve judgment. I believe that South Carolina can become a pocket of mercy in the coming time of judgment. I do believe in state sovereignty. I believe that it was the states that created the federal government. And my solution is not to wait for the other states to get their act together. Let's start enforcing the power that we have reserved in the 10th Amendment right now. What we're doing, there's a bill that was just introduced. I don't have the number on me, but believe it or not, it was crafted by Chris Crawford, of all people. Representative Crawford was one of the big opponents of our bill in the beginning, privately, to stop Obamacare. These were the hospital associations and whatnot. But Crawford crafted this bill. It's got Bannister, Delaney, Todd Rutherford, one of the Democrats, as a co-sponsor. You know what it is? It's to nullify the NSA. It basically is saying the same thing that the Tom Davis Amendment does. We're not going to aid and abet your usurpations. If you want to come in and do it, that's fine. You're going to have to do it. The dirty secret is that the federal government does not possess the bureaucratic mechanization to come in here and do it for all these other states. Right now, I mean, there's bills that are going to do the same thing against the NSA and a number of other states. I'm working with the founder of the 10th Amendment Center, Michael Bolden. This guy eats, breathes, and sleeps nullification bills, or whatever you want to call them, 10th Amendment bills, anti-commandeering. That's the main approach. They suggest not using the Calhounian form of nullification, although we retain that sovereign right to do so. But the probability of it passing in our current representation as far as their education level is very unlikely. But these bills, look, last year they called Representative Chumley and what we were doing, we were from the nut caucus. It's like, are you kidding me? Nullification? You can't do that. Supreme Court law, federal law trumps state law, blah, blah, blah. And now we got a Democrat introducing a nullification bill, or co-sponsoring a nullification bill to stop the NSA. The tide is turning. The truth is much more powerful than the lie. It's taken a long time for us to degenerate into an ignorant, uninvolved, and distracted society. But I believe that we can set fires, brush fires, in the minds of men if we just are willing to speak the unpopular truth in an age of dissent, if we stand on principle. And so I believe that the solution is available to us right now. We don't have to wait for California, Connecticut, New York, all these other states to get their act together.
We have time for one more question and then closing comments. This man's impatient. He's had his hand up. Yes, sir. What's your name?
Jim.
Okay, Jim. Where's yours, buddy?
Okay, I'm a big advocate of education. I'll keep that from turning into this. Gentlemen think it's time to add another element. It could be education and this kind of effort.
We're going to let you smidge away.
Okay, let's just answer his question, and then we have a plan to educate people.
Yes.
If we're talking about educating people,
Right.
and there needs to be a plan in place.
Do you?
I'll tell you, they've been doing that for a long time, like Jim said. They not only have a plan, they have a wonderful plan. Kudos to them for that. They've been doing that for 60-some years. They've been doing a tremendous job of educating.
Society's dumbing down, and I don't see a whole lot of it out there, so.
That's right.
I
Well,
can't
public
hear
schools aren't our
is
friends.
that-
That's the problem.
Yeah, it's essentially.
Clarify your question if you want to.
Pardon?
Forget it. I was going to say clarify your question.
Well, Alexis de Tocqueville, 18th century philosopher and historian, came to the United States early on in our founding. He was just blown away at the early success of America. He said, man, I can't believe how great America is doing. And he wrote a book and he detailed his findings when he came to the United States. One thing that he said is very profound. He said that American citizens are the most educated and enlightened citizens in the world. Every citizen is taught the leading features of his constitution, doctrines of its religion, and the history of their nation. He said to find somebody not perfectly acquainted with all these things is very rare. But to find somebody wholly ignorant of them is somewhat of an anomaly. Oh my gosh. Look how far, I mean, you can say the opposite's true now. I mean, we truly have. And look at the conspirators on the other side. They know, what is the biblical principle? You raise up a child in the way they should go, and when they're old, they won't depart from it. The other side is twisted, that perverted that principle. We're taking the children, they educate them, raising them up. Look, it works for them, right? But we just been totally distracted because Dancing with the Stars, Prince William, football's back, everything's okay. The matrix of distraction and control is prevalent. And Bernays and Huxley of old, the propagandists, have absolutely, their ideas controlling society have been so perfected through technology. The propaganda that's prevalent in the United States alone is breathtaking. PR, public relations, was first coined by Edward Bernays, who wrote the book Propaganda in 1926. He said that those that control the unseen mechanism of society, to basically control, mold the minds and opinions of people, they're the true ruling elite, right? And so education, you cannot ignore it. I agree, man, there's just not enough of this. Historically in the John Birch Society, we have about 300 to 500 members that are having a steady diet of our literature, the New American Magazine, the monthly bulletin, that are reaching out to their family, friends, and neighbors. But when you have about 300 to 500 Birchers in a congressional district, every time the voting index scores that we have, we give them a score rated on the U.S. Constitution. Every time when we reach about 300 to 500, I think it can be less now because of technology and whatnot, about 200 people, those scores rise and they become constitutionalists. I mean, every single time you see that. It's not, I was so shocked when I took this job to see how few people actually make a difference and get involved. A lot of people are just so distracted with things that are meaningless, but we are at war. There's been a war brought to our doorstep, and I call people daily to answer that call and join me and fight the tyranny of our day.
I get to answer the question. I would give you a sure because that wasn't an answer. No. They've done a great job of educating. I've been doing it for 15 years. It's my heartbeat to do that. It's not enough. Rome is burning down in front of us. This guy right here that I showed you earlier, he said we're both saying the same things right here. We need to educate. He said, and enlighten people and understanding. He was talking about the Constitution. That was at the Virginia Ratification Convention. There was great debate going on between anti-federalists and federalists. And this guy stood up and said, hey, chill out. Everybody calm down. This kind of people will never let it be perverted. So we have, and I'm just here to tell you, we have a public education system that is designed, I will submit to you, maybe you'll disagree, that it is designed to produce a status. A status is somebody beholden to the government. It's designed to do that. And it is, people say the public education system is a failure. They haven't studied the history of the public education system. It is an absolute success. It's doing exactly what it was designed to do. Go back to 1920 and look up John Dewey and Charles Potter. Those were signers of the Humanist Manifesto. They were socialists. They set up a system to create people beholden to the government. So what I'm telling you is we're running against the tide right here. We got to keep educating. Appreciate what they're doing. I'm going to do it no matter what. But I'm telling you, so the answer to the question is, that is not enough.
All right, folks, we're going to do closing statements here. We just don't have enough time, folks. But I'm sure you're going to be able to discuss this amongst yourselves, and I don't think these gentlemen are going to just run off out of the room either. So you may want to continue a little bit. Take a deep breath, guys. Need a glass of water?
I'm good. I've been Rubio all night.
All right, good. Well, closing statements, and then I'll have a little bit of closing remarks, and we'll break in prayer. Jesse?
Sure. For me, I don't want to be the smartest guy in the gulag. Hey man, I told you this was coming. It's not about educating so I know a bunch of stuff and I can argue with my friends all day. So what I can do effectively, the first step is to realize that we've got a problem. Man, Barack Obama has done a great service for us to really expedite the fact and the awakening of the fact that, man, we've got a problem. Houston, we've got a problem. And but then what do we do about it? A lot of people just scream at their television all day long, or they want to get together and eat, meet, and retreat and have a social complaint session. No. It's not about, just getting together and complaining. What are we doing about it? And so that's what JBS does. We're educational activists. When you come to our meetings, we educate you on the current event, on the principles that made our country great, the issues that are at hand. What are we doing about it? We give assignments. We're doing stuff. And that's why we're attacked. That's why the insiders hate us, because we're not just eat, meet, and retreat. We're actually involved. Just remember, if you can take away from everything tonight, don't forget the evidence that I brought up, the facts, and all these people that are saying that there's no effective way to guarantee the limitation of convention. If I was presented with evidence tonight by Bob that there was a guaranteed limitation on this, then I would be all for it. I mean, for goodness sake, yeah, let's get rid of all these bad amendments that were passed. But when you realize that this is, you have far left groups that are really good at organizing. George Soros is Mr. Coup d'etat. He's famous for overthrowing governments, and he's saying, no, let's have an Article 5 convention. That woman that I was telling you about, I had to stop the professor. She gave a speech. We need to get rid of the guns and rewrite this Constitution. For goodness sake, so antiquated, But her proposal at the 10-minute, you can watch it on YouTube. This was 4 months ago. She said, our solution is Article 5, Convention of States. This is what we got to do. And so, when you have all these other guys that are way better at organizing than our side, that are, definitely have read Article 5, and understand it can't be limited, that scares me. Especially when I'm using the 10th Amendment, the Constitution, to push back against the federal government. My solution is not to just sit there and educate and stay the course. No, I'm in the churches every day. So is the John Birch. All of our members are. I see handfuls of you guys that, man, we're holding the coldest day of the year signs outside the Chamber of Commerce for betraying South Carolinians a couple weeks ago. We're in the trenches. We're getting the job done, and we're about to, really, usher in a new wave of federalism that's been absent for quite some time. But I would just suggest that don't forget the fact that they changed their ratification requirement before. That's something that cannot be denied. It was a fact that they changed the requirement for ratification. They could change it again. And until we accept the fact that there is no silver bullet, even though it would be a lot of work, what he's talking about doing, the possibility for it to run away is not a little bit north of impossible. I think it's far greater than what the Convention of States proponents suggest. And that's why I'm opposed. But I don't want to wait for the rest of the country to get their act together. Let's make South Carolina the free state right now, using the 10th Amendment reserve powers that are available to us. That's what I do. I educate people on the principles embodied in the 10th Amendment and every aspect of the Constitution. But I really appreciate you guys. I know me and him are both extremely passionate. I still have still the utmost respect for Bob. But just don't forget, all the different evidence I have. And I have a table of evidence over here with some more literature and DVDs on this matter. Guys, thanks for having me. And that's all I have to say.
And I'm very thankful to John Birch Society and for the things that Jesse does. His tireless work, and you guys that know Jesse, you know that. So I'm very grateful for that. Before you leave, make sure you pick up in the back. There is a handout back there of what Georgia just passed, of their statutory law they just passed to go along with their Article 5 application, binding their delegates, applying criminal penalties for somebody that wanders off the reservation. Please pick that up. Jesse made a comment up here earlier when you asked the question about is God, that's a very near and dear question because I don't take it flippantly about the fact is God on board or do we think well, I'm not sure exactly how you phrased it, but we pray every day for God. What's that?
Brilliantly.
Yep, so I'm sure. For God to find favor with what we're doing. And Jesse said that God should judge us, and I couldn't agree more. But I wonder if he feels the same way about judging us and not blessing the efforts of nullification. And I would suspect that they pray for God's blessing upon nullification efforts too. So that was kind of a straw man there. I just want to make sure we understand that we look at things fairly. We're asking God to bless it. We deserve His judgment and wrath for the blood of 60 million unborn children, and also for our blatant disregard for the rule of law. And one of the things I want to show you here as I close, and just hold up your hand when I'm done. I'm going to go until you tell me I'm done. Somebody hit the light real quick. I want you to see this. Romans 13 says that we are supposed to be in subjection to the governing authorities. Probably one of the most misunderstood or misdealt with portions of Scripture. The average Christian today, I believe, and I can bear this out from evidence, most people would tell you when you read this passage that, and I always ask my students, who's the governing authorities? Most people think it's the president or the Congress. And what our founders gave us in this document, it goes way back. Our founders got their ideas literally from the Protestant Reformation. There's a guy named Sam Rutherford in the mid-1600s that wrote a book called Lex Rex, Law is King. Today we say big deal. So what? It would have got your head cut off back in that day because the prevailing political thought of the day was Rex Lex, King is law. But those ideas were picked up. The founders, the Puritans, the Scots, the Presbyterians, the Huguenots, all of them got their ideas from the Scriptures, particularly the Geneva Bible. But what they put in here was the governing authority changes depending upon which country. And the application in our country is different than, say, it would be in Saudi Arabia. Who's the governing authority? It's the king in Saudi Arabia. See, in our country, we don't have a king. What they did was they set law above man. And our United States Constitution is the governing authority. And I have people say, no, it's really the president. Well, why does he take an oath to the United States Constitution?
Amen.
The United States Constitution, now as a Christian, God's law is the highest law. But we don't live in a theocracy. Our founders understood that people come to Christ, they come to Him by the drawing of His Holy Spirit. He doesn't force it on anybody. And our founders understood that and created a system of liberty. We are to be in, so my point to you tonight is as you leave, we are to be in subjection to the governing authority, which is the United States Constitution. We have no right to disregard any portion of it, to knock it down and disregard it. We are called as Christians. If you're not a Christian here tonight, just bear with me. But I want to speak to my brothers and sisters in Christ. We are called to obey the rule of law in our country. And before we try a bunch of other ideas, and I'm not opposed to other ideas, I think we got to do a lot of different things, but we must exercise according to the rule of law. The founders gave us a provision in that document. They said, when they get abusive and oppressive, here it is, use it. Today, we're having battles and debates, we're wringing our hands. They're crying out to us, telling us, use it, trust us, work hard at it, do it. It's not easy, it's not a sure thing. Are there liberal delegates going to come from Massachusetts? You betcha. But the playing field is ours right now. The states are red. They're not all hard red, but they're red. You are not going to get a rogue amendment past Mississippi. That's if you count the states down in percentage of Republican vote. The 13th state is Mississippi. It ain't happening, folks. And I just want to leave you with that. The rule of law. No one's more stand up for that than I am. S308, the restaurant carry bill. I wrote that bill. I'm not boasting here. I'm trying to tell you that I care about the rule of law. We had to fight tooth and nail for 3 years. Senator Mike Rose introduced that bill in January of 12. It went nowhere because Senator Knott sat on it. Okay? In January of 13, I had my senator, Sean Bennett, introduced it. Okay? It's a little piece of liberty to get back. My point is this. When you lose liberty, it's extremely difficult to get back. That's why Jefferson said the price of liberty is eternal vigilance. We've got to be vigilant. It was hard to get that bill passed to get it back. And my point to you is that enforce the law today. Enforce the rule of law with the rule of law. Use the Constitution to enforce the Constitution. Not a bunch of other different methods, which are fine to go after those. But first thing, as a Christian, I'm in subjection to the governing authority, which is not President Obama. It's not even any of the great senators that we have. It is the United States Constitution. I leave you with the last thing is if Jesse said he wished they would call me up. I wish they would, but they're not going to call me up. But maybe they'll call up Mark Levin, or Glenn Beck, or Rush Limbaugh, or Judge Napolitano. Yeah. The John Birch Society has a letter out there with Judge Napolitano. They're dressing down for advocating an Article 5 convention. It's there. I got it with me tonight. Okay? David Barton, one of the greatest historians from a biblical worldview today. All of these guys. It's not a crazy idea. Then they're all wrong. And I'm not saying they couldn't be wrong. They're fallible too. But it isn't just Bob Mensch standing up here. There's some great people advocating for this because they understand what we're facing. I guess that's our biggest difference. Thank you very much.
Thank you, Bob. Well, we are certainly blessed to have such warriors in our midst. And you too. You were all born to be warriors. There is no question. 2 Corinthians chapter 7, verse 14. You know what it says? Turn back, atone. God will heal our land. We don't know which way this is going to go. But pray for discernment, pray for atonement, look for guidance. Let's help and ask God to keep his hand on this country. Amen. It's important. We are at a crossroads, folks. Amen. He is bigger he's in charge. He's in charge. I am tremendously pleased and gratified that this group can come together on such a contentious issue and be so objective and fair with each other. When we walk out of here, whichever ways this thing goes, let's support the action so we get the right result. In the next 2 meetings, our next meeting is April 17th.